5 minutes and then read the complaint before we start. And then it just saves time so you don't have to do it on the record.
Yeah, of course.
Perfect.
It's a short one, so I wouldn't even
Yeah.
mind. Let's
Okay,
have it.
perfect. Thank
Okay,
you.
I'm gonna go get a cup of coffee. Okay,
Okay, sounds
bye.
good.
Okay, Kim, I'm about to talk to him right now.
Okay, thank you. Recordings.
Good morning. We're here today for the weekend in custody arraignment calendar. Today is Saturday, December 20th. Are there any special requests regarding the order of today's proceedings or requests for continuances before we begin?
Good morning, Your Honor. Darby Phelps for the state. So I know we have a couple of matters that will need to go last today. I think among those is Pablo Moreno.
Okay. Thank you.
And Your Honor, Julian Gregory for the defense. In addition to that case stated by the state, I would ask that Mr. Steenfot, Mr. Kyle Steenfot, Mr. Michael Wilson, and Mr. Nathan Peterson all be called at the end.
Oh, I think McCall was also requested to be at the end too.
Thank you.
He's the other one.
Perfect. Thank you so much.
Mhm.
Thank you. We'll go ahead and begin with our interpreter matters. So first we have Raul Belo Godinez, followed by Christian Dino Cruz.
Good morning. This is Jimena Fini, certified con interpreter Spanish NVF XP 610.
Good morning.
Ok, estamos en la causa del Raúl Bello Godínez.
Good morning. We're here today for an arraignment and a bail hearing.
Estamos aquí para la instrucción de cargo y fijar fianza.
Probable cause has been found.
Se ha encontrado motivo fundado.
Public Defender's Office has been appointed to represent the defendant.
La oficina de los abogados de oficio ha sido nombrado para representar al acusado.
Just for the record, the defendant is utilizing the services of a previously sworn and certified Spanish interpreter.
Para que quede en acta, usted está siendo ayudado, asistido por la intérprete jurídica.
Let's go ahead and begin with the arraignment.
Comenzaremos con la instrucción de cargos.
Sir, do you have a copy of your criminal complaint?
Señor, ¿tiene una copia de su documento acusatorio?
Sí.
Yes.
Is your full, true, correct legal name contained on line 7 of that document?
En el renglón 7 aparece su nombre verdadero y correcto.
Sí.
Yes.
Thank you. We'll go ahead and waive a formal reading and now we'll turn to the bail hearing.
Ok, vamos a entonces a renunciar a la lectura formal y ahora vamos a empezar con lo de la fianza.
I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 8 or a moderate risk utilizing that tool.
Ok, acá yo he recibido entonces la tabla de Nevada previa riesgo y usted salió con un puntaje 8, que quiere decir de que usted salió en moderado.
State, are you ready to proceed with the bail hearing?
¿Está lista para proceder la fiscalía con la audiencia?
Yes, thank you, Your Honor. The state's not objecting to an OR release.
Sí, su señoría, no nos oponemos a que salga de libertad bajo palabra de honor.
The state would request pretrial services supervision with testing for controlled substances.
Sí, vamos a pedir entonces que él tenga algún tipo de supervisión y que le hagan pruebas al azar para ver por sustancias ilícitas.
And the basis for that request is the defendant has a misdemeanor conviction earlier this year for possession of drug paraphernalia.
La razón es, en la base de ello, es porque el acusado tenía un delito menor por tener en su posesión parafernalia para drogas,
Which was reduced from possession of a controlled substance.
que fue reducido de posesión de una sustancia ilícita.
And I would also request no contact with the victim business.
Y también voy a pedir que no haya ningún tipo de contacto con la víctima de este negocio comercial.
And for the record, that would be
Ministerio Palabra de Vida.
Y eso sería para el acta Ministerio Palabra de Vida.
defense.
Defensa.
Your Honor, at this time, I would join in the request for no recognizance release. I have no objection to pretrial supervision or the no contact order.
Ok, su señoría, yo no me voy a oponer entonces a la repetición de que él pueda salir bajo la palabra de honor y que no haya y la orden de no contacto.
As far as the random testing, I don't believe that there's a nexus in this case, but I will submit to the court.
Ahora, en cuanto a lo de hacerle pruebas al azar por sustancias ilícitas, no creo necesario, pero lo voy a dejar al criterio de la jueza.
Thank you.
Gracias.
I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community.
Ok, sí creo que un medio restrictivo tiene que ser usado entonces para asegurarnos del bienestar de la comunidad y la seguridad.
You will be granted an own recognizance release here today with the following conditions.
Usted será otorgado su libertad bajo palabra de honor con las siguientes condiciones.
You are required to be supervised by pretrial services.
Usted es requerido de que lo supervise los servicios previos al juicio
And you must check in with pretrial services within 1 business day of release.
y usted tiene que entonces reportarse con ellos un día hábil después de que usted haya salido de libertad.
You are required to have no contact with that named business as discussed.
Usted tampoco puede tener ningún tipo de contacto con ese centro comercial, como ya lo dijimos.
And must stay 100 feet away from that location.
Tiene que mantenerse 100 pies alejados de esa locación.
The court does not find that the state has met its burden to require that testing occur in this case.
Y creo que la fiscalía no ha probado completamente de que sea necesario hacerle las pruebas al azar.
That will be the order of the court, and we will set an arraignment for. Oh, we just had the arraignment. Thank you. Defense counsel, what hearing are we setting next? Thank you, madam.
Ok, entonces, con eso vamos a dejarlo así. Ya tuvimos su instrucción de cargos.
Your Honor, this time we'd be requesting a prelim within 15 days, please.
En este momento vamos a pedir una audiencia preliminar para 15 días más, por favor.
Thank you, Madam Clerk.
So the 15th day falls on Saturday, January 4th.
Do we have anything on the 31st?
We could do Friday the 2nd,
Okay,
but because he's out of custody,
isn't okay.
okay, so we want to do Friday the 2nd.
Well, do we have anything on the 31st?
That whole week is, yeah.
Okay, thank you.
And then we will do
Yeah,
motion to confirm. Motion to confirm will be December 24th.
Thank you. So the motion to confirm will be December 24th at 1:30 p.m.
Que la moción para confirmar será para el 24 de diciembre a la 1:30 de la tarde.
And the preliminary hearing will be January 2nd at 1:30 p.m.
And the motion to confirm will be at 3.
Oh, my apologies, 3 p.m. Thank you. And sorry, the motion to confirm will be at 3 p.m.
Ok, la moción, perdón, para confirmar será el 24 de diciembre a las 3 de la tarde y la audiencia preliminar será el viernes 2 a la 1:30.
And the preliminary hearing will be at 1:30 p.m. on the 2nd. Thank you.
Entonces la audiencia preliminar será a la 1:30 al día 2. Gracias. Thank you.
Thank you, Madam
Thank you.
Interpreter. I believe
You're
that is all of our
welcome.
cases. Thank you. Have a great one. Wonderful
Thank you,
day.
you too. Bye. Bye, Julian.
Bye, Amanda. All right.
Next, we have Christian Sino Cruz, followed by Cesar Craig Jones.
Hasta pronto. Suerte, señor. Mr. Sino Cruz did waive his appearance today, Your Honor. We can proceed without him if the court so inclined.
Thank you. We're here today for both a first appearance and a bail hearing. Probable cause has been found, and the public defender's office has been appointed to represent the defendant. I am in receipt of the Nevada pretrial risk assessment, which indicates that the defendant scored as a 9 or a higher risk utilizing that tool. I just for the record, we'll go ahead and at this time turn to the bail hearing. State, please proceed.
Thank you, Your Honor. The state's not objecting to an own recognizance release, pretrial services supervision with testing for controlled substances.
Thank you. Defense?
Your Honor, I will submit on that. Thank you.
Thank you. I do find that there's good cause to grant that continuance, and we'll go ahead and, not my apologies, not grant that continuance. I will grant the release, and so I am granting an own recognizance release. I do find that there are least restrictive means that can be imposed. I will impose pretrial supervision. Just note that if this comes in and it is the criminal complaint indicates that it is a misdemeanor, that will be it will be changed to be that he's required to be supervised by Reno Justice Court. And so I'll just note that for the record that may change. And we'll go ahead and I will require that the defendant be required to be subjected to random drug and alcohol testing. Cannot use any controlled substances or alcohol unless has a valid prescription. And we'll go ahead and set that arraignment, and that will be set for January 7th at 9 a.m. Thank you.
Thank you, Your Honor.
Cesar Craig Jones, followed by Sean Fry. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 10 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So yes, Mr. Craig Jones scores a 10 on the risk assessment. He also has a fugitive hold. That's on a fully extraditable no bail warrant out of California. The date of that warrant is February 2nd of 2025. Already this year, he's got a felony conviction for felon in possession of a firearm. That's out of California. He was also arrested in that case on CCW and shoot at inhabited dwelling. 5 warrants are listed on that case. 2024, he's got a felony arrest for possession of a stolen motor vehicle and a parole violation, also out of California. That case had 2 warrants listed. 2022, a felony arrest for robbery and threatened crime with intent to terrorize. The disposition on that was prosecution deferred for revocation of parole. 2021, a felony arrest for felon in possession of a firearm in CCW. That was out of California with no disposition. 2021, a felony arrest for first-degree murder and carjacking, also out of California. That one shows a disposition of release for further investigation. He's got a felony arrest for arson in 2020, a felony arrest for failure to appear, a misdemeanor conviction for assault in 2020 on a 2016 case, a misdemeanor arrest for indecent exposure in 2020, a felony conviction in 2017 for shoot at an inhabited dwelling, a felony arrest for failure to appear in 2016, a couple of misdemeanors in 2015, a felony arrest for robbery in 2015, which was dismissed. He's got some juvenile history out of California as well. In this case, he is charged with, or he looks like he will be charged with, attempted burglary with a deadly weapon, resisting with a firearm, possession of a firearm by a prohibited person, carrying a concealed weapon, possession of controlled substance, and possession of burglary tools. So we're looking at some similar offenses to what he's got in his history. And as I mentioned, he has a criminal or felony conviction already this year for felon in possession of a firearm, which also included apparently allegations of shooting into a dwelling. So he's a very dangerous individual, very high risk of continued criminal conduct, future non-appearance. The likelihood of conviction in this case, I would note, is very high. The car burglary was witnessed by officers who then witnessed him trying to discard the firearm, an act which was also caught on video. He's got an atrocious criminal history, so the state's requesting bail in the amount of $100,000, DA or pretrial services, supervision, and no firearms.
Thank you. Defense?
Your Honor, this time I'd be requesting Mr. Craig Jones's owner cognizance release. I understand he's got that fugitive hold, but in spite of that, I am making that request. Your Honor, he does reside in Oakland. He was in Reno visiting. He's indicated to me that he is willing and able to remain in the area while the case is proceeding. He does have a personal phone number as well. We were not able to verify this information independently, although I have no reason to doubt what he has represented to me. $100,000 is well beyond what he can afford and would amount to a de facto detention order against him. So with that in mind, Your Honor, I would be asking for the owner cognizance release, or in the alternative, a nominal bail setting, perhaps of $5,000. With that, I would submit it.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment, the factors as contained in NRS 178.4853 and NRS 0.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and the appearance of the defendant. I will note for the record that a detention order is appropriate given all the facts and circumstances in this case. Bail will be set in the amount of $80,000 that is bondable with no 10% cash option. Just based off of the history of the failure to comply, the history involving firearms, the history of violence, and the likelihood of conviction, as well as the lack of ties to this community and we'll just note that for the record. If the defendant is able to post that bail amount, sir, you will be required to be supervised by pretrial services. You must check in with pretrial services within 1 business day of release. And you are also ordered to not possess any firearms or weapons based off of your criminal history as well as based off of the allegations. That will be the order of the court. I'm not imposing any other conditions, and I will require that we set a 72-hour hearing, which will be set for December 26th at 9:30 a.m. Thank you.
Thank you, Your Honor.
So what do you need $8,000 for the phone?
Sean Cry, followed by Kayvon Dang.
I'm gonna do California. Sorry, sir, we gotta go. I'm sorry. It won't happen until after this case. Sean's
Defendant Mr. Cry,
here.
present.
He is not present, Your Honor. He refused today. I think he's feeling ill. If we could pass him for a day, please.
Thank you. I'll note that in RCR 2025-133454A, the Public Defender's Office has not been appointed to represent him. I will appoint the Washoe County Public Defender's Office based off of that he is appointed in the other matter. Just for the record, in RPC 2025-064975, probable cause has been found and the Public Defender's Office has been appointed to represent him. We will go ahead and continue the bail hearing and the arraignment for tomorrow at 9:30 a.m. Thank you.
Thank you.
Brandy Old, followed by Christopher Ochevega.
Your Honor, Miss Ole is also ill today, I believe. So I'd be requesting a one-day continuance for her as well.
Thank you. We are here today for three separate matters. Just for the record, in RPC 2025-064978, probable cause has been found and the Public Defender's Office has been appointed to represent the defendant. We will go ahead and continue the this case just for the bail hearing as well as the other two cases. I do find that there's sufficient good cause to grant a continuance until tomorrow at 9:30 a.m. Thank you.
Thank you.
Christopher Ochevega, followed by Rayson Davis. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the Public Defender's Office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which in this case indicates that you scored as a 7 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. I was just reviewing this case for victim contact. It looks like we were able to make contact with the named victim this morning. She says that she has been a prior victim of this defendant. He is in custody on a domestic battery. I believe she's the victim in that case. And she says that he does own a handgun, or she's seen him with a handgun is what she says. So he's in custody on this case for violating a domestic TPO, 9 counts of that. He called her from the jail 9 times the very same day he was served with a temporary protection order. So he's not very inclined to follow court orders, it appears. He scores a 7 on the risk assessment. As I mentioned, he's also in custody on a domestic battery. He was arrested on that one on December 17th. That's a Reno Municipal Court case. 2024, he's got a misdemeanor conviction for disturbing the peace that was reduced from a domestic battery and a false imprisonment. And notably, that case involved a different victim. So he's both a very high risk of continued criminal conduct, non-compliance, and he's a danger to the community, specifically women. So the state's requesting bail in the amount of $5,000, pretrial services supervision if he's able to post, and no contact with the victim.
Thank you. And just to confirm, you indicated that he's likely in custody on involving the same victim. Do you have information as to whether or not it is the same victim or a different victim that he's currently in custody on for the domestic battery?
So I can look at that right now, Your Honor, and see if I can pull up that information on the Reno Municipal Court website.
Thank you. And what, again, was the amount requested?
$5,000.
Thank you.
And I'm sorry, Your Honor, I missed the state's request as far as conditions.
Oh, I requested pretrial services supervision, no contact with the victim, and I failed to mention this, but I would request no firearms.
Thank you.
Thank you, defense.
Thank you, Your Honor. At this time, I would be requesting Mr. Ochoa's own recognizance release. He is 22 years old. He's a lifelong resident of the Washoe County area. He currently stays with his parents in Sparks. He does have a phone number as well. And he just started warehouse work at a warehouse called Ollie. That's Ollie. Your Honor, there is, as he just started, he does not have anything in savings. He's very young. There is no amount of bail that he can afford. Even $5,000 would be a de facto detention order against him. I have no objection to pretrial supervision, as well as the no contact order and the no weapons clause. I think that those conditions can ensure his compliance with that no contact order, as well as his return to court, and reduce his risk of recidivism. With that, I would submit. Thank you.
And Your Honor, I was able to look up that Reno Municipal Court case. It is the same victim. Police contacted her. She was with RIMSA. She had numerous injuries on her body. She reported that he beat her with a belt. And I would also note that she contacted police in this case to let them know that that he was violating the TPO.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment, the factors is outlined in NRS 178.4853 and NRS 178.498. The court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and specifically the named victim in this case. I will note the history involving the same named victim, the likelihood of conviction, the history of violence, and with this, the history of that he's indicating that he's unable to comply with court orders. Bail will be set in the amount of $5,000 bondable with a 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by the Department of Alternative Sentencing. That will change depending on what occurs within where the Department of Alternative Sentencing will go. So just note that that supervision may change. Additionally, you are required to check in with them within 24 hours of release. You cannot possess any firearms or weapons, as this is, I'll just note the alleged crime of violence, but it's necessary in order to ensure the safety of the community. Additionally, you're to have no contact with the named victim in this case of Alessandro Salgado. You cannot contact or attempt to contact the victim in any way, including in phone, person, and electronic means, email, or through social media, either directly or through an agent. I mean, someone working on your behalf. That will be the order of the court, and we'll go ahead and set a 72-hour hearing, which will be set for December 26th at 9:30 a.m. Thank you.
Thank you, Your Honor.
Grayson Davis, followed by Kavion Ding. Good morning. We're here today for a first appearance. There's an allegation that the state of California is seeking to have you extradited. We'll go ahead and set a 72-hour hearing, which is the time where the state is required to provide a criminal complaint as to whether or not the state of California is requesting to have you extradited there. Just so you have the information that we have is that it's from a warrant from Santa Clara County with the bail listed amount of $70,000. We'll go ahead and set that 72-hour hearing, which will be set for December 26th at 9:30 a.m. Thank you. We'll see you back here then.
Thank you. See you soon.
David McComb, followed by Kyle. I'm sorry. Oh, thank you. Kavion Dang, followed by David McComb. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 3 or a low risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So Mr. Dang does score a 3. However, he has a misdemeanor conviction from October 29th of this year for DUI out of this court. He does have a suspended sentence in that case. And then prior to that, he's got a misdemeanor arrest for trespassing out of Las Vegas in 2020 with no disposition. Mr. Dang says he's interested in substance abuse treatment. I think that is absolutely appropriate, given the BAC in this case, very high, and his very recent criminal conviction for DUI. So the state's not objecting to an own recognizance release with direct transport to inpatient, pretrial services supervision with testing for alcohol, and no firearms.
Thank you. Defense?
I'm sorry, Your Honor, one moment, please. Your Honor, at this time, I'm requesting Mr. Dang's own recognizance release. I have no objection to supervision at this time, but I would object to the requirement that it be a direct transport to inpatient. If the court does set a monetary bail, then I would ask for that option, but I would ask that he be given the OR at this time based on his low NPRA score and the following facts. Your Honor, he's 23 years old. He's lived in the Washington County area for about 3 years. He has an address in Sparks that he could return to. He currently works as a production associate at the Tesla warehouse, and we were able to verify all this information through an independent third party. So I think given his ties to the community, the low NPRA score, I think that a flat OR is appropriate. Again, no objection to the other conditions. Thank you.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors is contained in NRS 178.4853 and NRS 178.498. The court does find that the state has met its burden by proof, or sorry, I apologize. I do not find that the state has met its burden, so I am granting an own recognizance release here today. I will require that the defendant be supervised by pretrial services. So you must check in with pretrial services within 1 business day of release. I am imposing the condition that you cannot possess any firearms or weapons as based off of the information provided. I do find that that is necessary as the least restrictive means in order to ensure the safety of the community. I am imposing the condition that you cannot use any controlled substances or alcohol unless you have a valid prescription be subjected to random drug and alcohol testing. Additionally, I am requiring that you complete 3 mutual support groups per week until you are in substance use treatment. So you must provide that proof to pretrial services. Just so you have that information, what mutual support groups are things such as NA, so Narcotics Anonymous, AA, Alcoholics Anonymous, are the non-secular versions of those programs. That will be the order of the court, and we'll go ahead and set an arraignment, which will be set for January 7th at 9:30 or at 9 a.m. Thank you.
Thank you, Your Honor.
I'm gonna let them tell us.
All right.
Thank you.
There's your
I appreciate that.
Yeah, thanks. Goodbye.
No. Well, first we got Dave in the call, right? And then. Okay.
So Your Honor, if Your Honor wants to take Moreno now, I think it would be a fine time to do that.
Thank you. I was just reviewing who we have left, and that's my understanding is we are all the individuals that the parties had requested to go last. So we'll go ahead and call Pablo Moreno, please. Good morning. We're here today for a first appearance at bail hearing. A probable cause has been found, and it is this court's information that a public defender's office has not been appointed, as you had indicated that you would retain private counsel. Sir, have you hired an attorney to represent you?
No, ma'am.
Okay. Do you want me to determine if you qualify for the services of a public defender to have the Washoe County Public Defender's Office represent you for at least this bail hearing?
Yes.
Thank you. So, sir, assuming that you were to remain in custody, approximately how much money do you are you able to make per week, if any?
Excuse me?
Are you able to make any money while you are in custody?
No, ma'am.
Thank you. Do you find that you qualify for the services of a public defender? So the Washoe County Public Defender's Office will be appointed to represent you in both matters. Just for the record, the court is in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 3 or a lower risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So just by way of kind of the history of this case, essentially we started the bail hearing yesterday in Sparks Justice Court. The state began to give arguments, at which point Judge Longley stopped me and indicated she felt like there may be some sort of conflict based on the facts that the state was relaying. So the case was continued today for Your Honor to preside over the bail hearing. In the meantime, the state did file an emergency motion to increase interim bail to $300,000 bondable, which was granted by Judge Wilson yesterday. So that's the status of things as we sit here right now. $300,000 bondable only on the assault with a deadly weapon PC, and then there's an additional PC, ad book PC for child abuse, and Judge Longley set it at just $1 since it really was part of the facts of the initial PC. So
thank you. And if I could, before you go into that, just because this is a Sparks case that was then transferred to us just for the purpose of the bail hearing, I just want to confirm that in the motion, because I did review the motion, of all that I have in there is indicating that there's additional facts. I just want to make sure that I'm not missing any documents where the state actually provided information.
You are not missing any documents, Your Honor. Essentially what happened was I was covering both courts yesterday and I needed to get that motion submitted immediately. I felt like it was truly a matter of community safety that I get that motion submitted as quickly as possible. And so I was actually drafted that motion as I was in Reno Justice Court covering cases yesterday. So while I would have loved to provide more information, I simply felt like it was such a matter of urgency that I needed to submit it as soon as possible. So I am going to provide the court with all of the facts today.
Thank you. I appreciate that. I just wanted to make sure, since this is transferring courts, if I'm not missing any documentation. Thank you. Please proceed.
Certainly, Your Honor, I appreciate that. So the state is requesting essentially a detention order level bail. And there are multiple reasons for this. The egregious facts of the case, which I will go over. I'll go over each of these in detail. Egregious facts of the case, his pattern of behavior, additional reports we've received from concerned citizens in the last 24 hours, attempts to destroy evidence, and possible attempts to retaliate against the victim while inside the jail. So first we'll start with the egregious facts of the case. The PC sheets, Your Honor, I learned from school police, they don't submit in the same way that other agencies do. So that's why when you see a PC sheet from school police, it's not going to be as detailed typically as we see from other agencies. So a brief summary of the facts. This defendant and another dad at Desert Skies Middle School got into an altercation over a parking spot during student pickup. According to Humberto, the victim, and his daughter, who's 11 years old, this defendant pulled out a gun and racked the slide. He then pointed the gun at Humberto, and then he pointed the gun at the 11-year-old child. And as he pointed the gun at the little girl, he said to her father, "Do you love your family?" And this is on school property. Shortly thereafter, officers located Pablo and conducted a traffic stop, during which time he was found to be in possession of a loaded Glock. So he scores a 3 on the risk assessment, but I did indicate to this court that he's got a pattern of behavior. So starting with his older criminal history, it's all out of Texas. It includes a 1993 child sex crime arrest, which was dismissed 3 years after arrest. A burglary of a building charge, which was dismissed after he completed diversion, it looks like, and a 92 misdemeanor conviction for DUI, and a 1997 conviction for unlawfully carrying a weapon. More recently, in 2023, he was arrested for resisting with a firearm, assault with a deadly weapon, and intimidating an officer. The state chose to charge resisting in that case. He pled guilty to the resisting. The facts are concerning in light of when you look at them in conjunction with the facts of this case. He caused a disturbance after his truck was towed from a handicap spot. He then went to the tow yard and made a comment that he's a member of the Sinaloa cartel and said someone was going to get shot. He then resisted being placed under arrest and said to an officer, "You're a dead man, motherfucker." And then I was advised yesterday by Officer Redman of the school police that there was a 2019 investigation into this defendant for very similar allegations. And if you'll excuse me, Your Honor, I have notes kind of all over the place, but I'm looking at them now. And the allegation in that case was that he approached another child at Brown Elementary School took photos of the child while in possession of a firearm. Now, candidly, no charges came of that, but I think it is noteworthy that he was investigated. And I do think that the court should consider it as a pattern of behavior. Additionally, the DA's office received a phone call yesterday morning from a concerned citizen. She indicated, well, we didn't speak to her. I was very busy, as I told Your Honor. I referred her to Officer Redman. She called Officer Redman. And she indicated that she was very concerned about this defendant. She said he had previously made threats to her and her child about the cartel and guns. And then we have staff at AACT. Apparently, this defendant went to AACT in the hours prior to this incident, the very same day, and made threatening remarks to staff members there. And then we have attempts to destroy evidence. Law enforcement was granted a search warrant because they listened to jail calls. And this defendant was instructing someone to retrieve his dash camera and destroy the evidence, destroy what was on that dash camera. And then, as I mentioned, we've got possible attempts to retaliate against the victim. This actually came up last night after I made the request for the increase to $300,000 bail. Police have continued to listen to jail calls. And again, Mr. Moreno knows this. I brought up the jail calls yesterday, and he continued to make jail calls that are incriminating. And in this one, officers relayed to me that it sounds like he's making possible veiled attempts to retaliate against the victim. He made a comment about going to their house. He didn't specifically say the victim, but he made a comment that they need to go to the house. And so Your Honor can take that for what it is. I take that as a possible attempt to retaliate against the victim, especially in light of his history, recent history in 2023, recent history in 2019, same day as this event, and with other concerned citizens. And so, Your Honor, school should really be a safe place for children. And, tragically, that's not the reality. But I think it's incumbent upon everyone. Everyone has a duty when there's red flags, to take action and to protect children in the community, when there are these red flags. And in this case, there are many. And so the state is requesting that the court retain the $300,000 bail, bondable only. Everything is being charged together. I did already draft the complaint. So if Your Honor just wants to retain the $1 as set on the child abuse until that's merged, that would be fine with the state. The state would request pretrial services supervision if he's able to post, no contact with the victim, Humberto Mendoza, no firearms, Humberto Mendoza as a condition and pursuant to statute, as well as his address. I forgot to mention the allegation that this defendant followed the victim and his child home after he pointed the firearm at them. That's a very important fact that I failed to mention to this court, and I apologize for that. So no contact as a condition and pursuant to statute, no firearms. And I would also request the additional condition of no contact with any Washoe County school. And with that, I'll submit.
Give me just one moment. Unfortunately, with the way that this works, the court has not received some of that information. So just to confirm with respect to the allegation that he followed the victim home, is that based off of information provided to the officer from the named victim in this case?
Yes, Your Honor. So essentially that information came through in the full police reports, the supplemental reports. That was information that was relayed to police through the victim witness, Humberto Mendoza, and his child.
Thank you. And then the court just has a question as to as contained in this documentation, it is a co-defendant is Humberto Mendoza.
So we're certainly not, they will not be charged together. So if Your Honor Your Honor, I think you're asking for information about why the victim is a co-defendant. Is that what
Well, the information I have is that, I have just that listed in the declaration is just victim, and there's no names, and juvenile daughter.
Yes.
And then it's co-defendant Mendoza Humberto.
Yes. So who's listed on the probable cause sheet as a co-defendant but will not be a co-defendant, it is Humberto Mendoza. His daughter's initial is AZ. And I can provide the court with her full name via email, and I can copy defense if you need that information, Your Honor.
Thank you. And then you indicated that the residence should be included.
Yes. And if I could email, I would like to email that information to the court as well.
So you will need to provide that to the court by noon, as well as provide it to defense counsel.
I will do that, Your Honor.
Thank
And
you.
then as it relates to Humberto Mendoza as a co-defendant, he was essentially arrested. He went back to the school to talk to officers at their request. Officers hailed him back to the school. And when he showed up at the school, they noticed he had a firearm. He had 2 firearms in his vehicle.
Thank you. And then I think, Madam Clerk, this might be a question for you. If I just do one judicial release order that contains both our RPC numbers, will that work when it gets transferred back to Sparks, or do I need to do separate?
Are you gonna leave the other one as the dollar though, or are you gonna put them both?
I would put it just both as one judicial release order.
Yeah,
Or just do one judicial release order based off that. Okay, I just wanted to make sure. So I apologize to parties if just based off of, since this is going immediately back to Sparks, this court is just gonna do one judicial release order that will contain both of the RPC numbers. Thank you, defense.
Thank you, Your Honor. I'm trying to think of where to begin here. First off, with regards to the motion that was filed yesterday, I understand there's likely no remedy. We're having a bail hearing here, but I would object to the state having filed that motion ex parte. We got into the bail hearing yesterday. It was my understanding I was appointed yesterday to represent Mr. Moreno. That motion was filed, that was an ex parte communication. I understand the state's concerns about the facts alleged in this case. However, I think I should have been served a copy of that and given an opportunity to respond.
Absolutely. So I will just put this for the record of this court will not address anything with respect to that motion as this case is only transferred for the purpose of addressing bail here today. So we will preserve any rights the defense has regarding any request to object or oppose to that bail motion, but you must do so in Sparks Justice Court.
Understood. I'm just making my record.
Absolutely. I just wanted to make sure that's clear.
Thank you. With that in mind, Your Honor, I would also object to the court taking consideration of any tip-offs from concerned members of the community, as the state noted. Your Honor, this is a case that has garnered significant media attention. I believe that there's going to be a lot of, for lack of a better word, unfounded allegations that are going to be a result from that. Turning to the bail factors, Your Honor, I spoke to Mr. Moreno. He is 56 years old. He has lived here since 2016, so almost 10 years now. He does have an address in Sun Valley that he does have an address in Sun Valley. Unfortunately, his wife has indicated that she will not accept him back at this time, but he's indicated to me that he can find alternative places to live. Your Honor, he does not work. He is on disability. As the court can see, he's on oxygen. Your Honor, he absolutely denies any affiliation with the Sinaloa. That whether that was bluster or inaccurate in the PC sheet, Your Honor, I don't know, but he absolutely denies any affiliation with that organization. I will also note that he does take medication for PTSD and anxiety. I don't want to get into what those medications are right now, but I believe that absolutely goes hand in hand with his disability status. He does also receive Medicare. At this point, Your Honor, $300,000 is absolutely beyond what he can make. And I know that he's got a storied history. Most of it, however, is stale. I would ask that the court not impose the $300,000, as I believe that there can be conditions crafted to ensure the safety of the community, as well as the risk of recidivism and his return to court. Your Honor, not least of which would be pretrial supervision, the no contact orders, the no weapons order, and the stay away order from Washoe County Schools. With all of that in mind, Your Honor, I would be requesting that under cognizance release, and I would submit it on that. Thank you.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment, the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and specifically the named victims in this case. The court did not hear anything with respect to the defendant's ability to make any amount of money in terms of with respect to the factors. I'll just note that for the record. However, given all the information provided, the court does find that a detention order is appropriate. So based off the information that this court has with the history of violence, the threats of violence, including violence involving firearms, the likelihood of conviction, the court will consider also the very concerning allegations as reported in this with respect to the threat to the community and specifically the named victims in this case from the defendant's own words as contained in the jail telephone calls. I will just note that for the record, as well as the court will note the concerns of the additional reports, and I'll just note that they're concerned. So the defendant is presumed to be innocent of those charges. However, given all of the pattern as discussed, the court does find that is sufficient in order to determine that a detention order is appropriate in this case. Bail will be set in the amount of $200,000. That will be bondable with no 10% cash option. I am imposing the conditions, so just to make sure that you are clear that begins immediately. You are to have no contact with Humberto Mendoza as well as the minor child with initials A.Z or their residence. You cannot contact and must stay 100 feet away from the named victims. You cannot contact or attempt to contact the victim in any way, including in person, phone, text, email, electronic means, or through social media, either directly or through an agent, someone working on your behalf. I am also imposing that this is pursuant to NRS 178.4845 for a period of 120 days. If you violate this court order, you could be charged with a misdemeanor found in contempt pursuant to NRS 22.010. Have these conditions modified, have your release revoked, be remanded to custody, and or any other legal punishment. I will just note for the record with respect to the amount of, that is also based off the, again, what the state has been able to prove here today. So that's why it can't be a higher amount. Just note that for the record. With respect to supervision, I will require that if the defendant is able to post that bail amount, that he be supervised by pretrial services. So sir, you must check in with pretrial services within 24 or within 1 business day following your release. You cannot possess any firearms or weapons based off of the allegations as contained. I do find that it is that is necessary in order to ensure the safety of the community. Based off of the agreement of the parties, I am including a no contact order with Washoe County schools. So you must stay 100 feet away from any school in Washoe County. I believe that that is all the conditions. I'm just reviewing the other judicial release order, and I believe that contains all of the requests. Just want to confirm. State.
Yes, Your Honor, thank you.
Thank you. So just to make sure that it's clear for the record, but it was 1 judicial release order that contains both of those RPC numbers. And at this time, Reno Justice Court will close our case and it will be transferred back to Sparks Justice Court for the remainder of the proceedings. Thank you.
Thank you, Your Honor.
And they have their dates set first, or do we need to confirm those?
Thank you. We'll just confirm for the record of the information that this court has is that a 72-hour hearing has already been set for December 22nd. So I just wanted to make sure that the parties have that.
I'm sorry, Your Honor, I missed that.
No problem. The information that this court has is that the 72-hour hearing is set for December 22nd, Sparks Justice Court. Just want to make sure you have that information.
Perfect. Thank you, Your Honor.
Thank you. Defense counsel, which case would you like to call next?
Wilson. Let's call Mr. Wilson, Your Honor.
Okay. Michael Wilson? Good morning. We're here today for a first appearance bail hearing. Probable cause has been found. The public defender's office has not yet been appointed to represent you, as you'd indicate that you would retain private counsel. Did you hire an attorney to represent you?
No, Your Honor.
Okay, so we can proceed here today. I can continue it to see if you wish to hire an attorney for the purpose of the bail hearing, or I can see if you qualify for the services of the public defender. How do you wish to proceed?
Public defender, Your Honor, please.
Thank you. So, sir, assuming you are to remain in custody, approximately how much money do you make per week?
About 600.
Is that if you're in custody?
Are you able to still make
Oh.
that amount while you are in custody?
No.
Thank you. I do find that you qualify for the services of the public defenders. The Washoe County Public Defender's Office will be appointed to represent you. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So Mr. Wilson is situated quite differently than some of the others we're going to see this morning on similar cases. The facts of the case aren't as egregious. However, they still are what they are. They're still child sex crimes. He scores a 4 on the risk assessment. As far as criminal history, he's only got one arrest, a 1993 felony arrest for embezzlement. Looks like out of Michigan with no disposition. Given the nature of these charges, everything that surrounds the child sex trade, the state does believe that there's a community safety issue. The state would request bail in the amount of $10,000, pretrial services supervision, and no contact with minors.
No contact or no unsupervised contact?
No unsupervised contact, Your Honor.
Thank you. Defense counsel?
Your Honor, at this time I'm requesting Mr. Wilson's on recognizance release. Your Honor, he does have an address that he could return to. He is also employed as a server or bartender. Your Honor, given his low NPRA score, I believe there can be conditions crafted to ensure the safety of the community, not least of which would be pretrial supervision and no unsupervised contact with minors. I believe that that would be appropriate here. $10,000 is well beyond what he can make right now and would amount to a de facto detention order. With that, I would submit it.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment with factors is outlined in NRS 178.4853 and NRS 178.498. The court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. The court will note the likelihood of conviction as set forth in the declaration of probable cause, as well as with the nature of the charges, the significant threat to the community. With that, bail will be set in the amount of $10,000. That will be bondable with no 10% cash option. If the defendant is able to post that bail amount, sir, you will be required to be supervised by pretrial services. So you must check in with pretrial services within 1 business day of release. You are ordered to have no unsupervised contact with minor children, and that is due to community safety. We will go ahead and set a 72-hour hearing, and that will be set for December 26th at 9:30 a.m. Thank you.
Thank you, Your Honor.
Defense counsel, please call the next case.
If we could call Mr. Steenfot.
Thank you. This is Kyle Stephenfott.
Yes.
How do you say your last name? My apologies.
It's STEE
How
and
do you say it?
Steenfott.
Thank you. We're here today for first appearance bail hearing. Probable cause has been found. The public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 7 or a moderate risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So as Your Honor noted, he scores a 7 on the risk assessment. He was scored 1 point for violent criminal convictions. As far as criminal history, he's got a misdemeanor arrest this year for contempt out of Carson City. He's got a misdemeanor conviction for battery in 2021, misdemeanor arrest for battery in 2020, which was dismissed, another misdemeanor arrest for battery in 2020 with no disposition. Then back in 2010, he's got a misdemeanor arrest for domestic battery with no disposition. Your Honor, we see a disturbing number of these cases, quite frankly. And the things that this defendant said are among the most unhinged. I'm going to read some of them for the record. So first, he was very pushy with her, called her incessantly, a total of 49 times in a 24-hour period. This is someone who he believes to be a 15-year-old child. He told her multiple times he wanted to get her pregnant, even after she said she didn't want to get pregnant. At one point, he called her and left a voicemail that said, "I made you my prostitute, girl. You're my prostitute now. So you do what I say. You listen to what I say. I do. So we're going to fuck." He left her another voicemail describing how he was going to have sex with her and said, "I'm going to fuck you like a donkey." He then admitted everything when he was detained. He admitted he knew the law. Very importantly, Your Honor, he also contacted another page, which was run by an undercover detective, posing as a 14-year-old girl, and he was aggressively requesting sex from her as well. Just a very incredibly high risk to the community. There are no least restrictive means to keep the community safe from child predators like this defendant. As I mentioned, he's got a history of violence, which makes him even more dangerous, especially coupled with his incredibly aggressive, sexually deviant behavior to whom he believed was a child. So the state's requesting bail in the amount of $500,000 bondable only, pretrial services supervision if he's able to post that, house arrest with GPS prior to release, no contact with minors, schools, or places where children frequent.
Thank you. My apologies. What was the amount requested?
$500,000, Your Honor, bondable only.
Thank you. Defense.
Thank you, Your Honor. At this time, I would be requesting Mr. Steenfot's own recognizance release. I believe there can be conditions crafted to ensure the safety of the community, not least of which would be pretrial supervision, the no contact order, and if the court sees fit, the GPS monitor, although I would ask that he be allowed to get that installed within 24 hours of release, given the difficulty of expense incurred in getting that set up at the jail. Your Honor, he currently lives in a group home. He is on disability, receiving Social Security payments. There is no amount of bail that he can make. $500,000 is well beyond his abilities. This would amount to a de facto detention order against him. Your Honor, he was, I will note in my reading of the PC sheet, he was cooperative with officers when they took him into custody. I believe that this is a situation where, well, I don't want to get too far into the weeds here, but I believe that there can be conditions crafted. With that, I would submit it.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in order to ensure the safety of the community and the name. Well, I'll just put the safety of the community. The court has noted that the likelihood of conviction is very significant in this case based off the defendant's own statements, as well as based on the defendant's own statements. The threat of harm to the community is significant as well, based off of the nature of the charges, as well as the allegations as contained with the information provided. The court is concerned, as discussed, with the nature of the contact as well, and with the that it's not only just one individual, but the two individuals that's listed in just this probable cause sheet, and with the allegations in terms of the statements as well. With that in mind, the court does find, and the history of contempt is concerning to the court as well, as part of the factors in this. And so with that in mind, a bail will be sent in the amount of $250,000 that will be bondable with no 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by the pretrial services. The three must check in with pretrial services within 1 day of release and 1 business day of release, and you are ordered to have no unsupervised contact with minor children. The court finds that that is necessary in order to ensure the safety of the community, and the court will not be imposing additional requests as the state has not provided sufficient information. So that will be the order of the court, and we will go ahead and set a 72-hour hearing, which will be set for December 26th at 9:30 a.m. Thank you.
Thank you, Your Honor.
Defense, your next case, please.
We've got Mr. Peterson.
Thank you.
We've got Mr. McComb next, Your Honor. I'm sorry.
Okay, thank you. Good morning. We're here today for first appearance bail hearing. Probable cause has been found, and the public defender's office has been appointed to represent you, just to make sure that you were David McComb, correct?
Yes.
Thank you. I'm going to receive the Nevada pretrial risk assessment, which indicates that you scored as a 0 or a low risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So as Your Honor can tell from the risk assessment score of a 0, he has no prior documented criminal history. However, on balance, the facts of this case certainly necessitate a detention order level bail. The likelihood of conviction is very high, first of all. So the defendant pursued who he believed to be a 14-year-old child, with whom he sent explicit photos, shared explicit photos. He attempted to pick her up at her home, take her back to his place for sex. He acknowledged to her all the possible consequences of his actions, all of them. He listed them, and then he did it anyway. And this matters because it shows that consequences just are not enough to stop him. There are no least restrictive means to keep the community safe from child sex predators like this defendant. So for that reason, the state is requesting a detention level bail in the amount of $300,000, bondable only, pretrial services supervision if he's able to post, house arrest with GPS prior to release, and no contact with minors. I would request no contact with schools or places where children frequent, but I understand the court's position on that.
Thank you. And just for that amount, do you have any information regarding the defendant's means in order to justify or for the court to have some more information as to how that is an appropriate amount?
So, Your Honor, the state has no information whatsoever about the defendant's finances. So when I pick a number and I want a detention level bail, I pick one that I think will be high enough. Sometimes that's not the case. Sometimes we pick a number like this and defendants surprise us and they're able to post. So frankly, sometimes I'm inclined to ask for more. I try, to be somewhat reasonable. However, I just want to be clear that I am requesting detention level bail with the hope that $300,000 would satisfy that.
Thank you. Defense?
Your Honor, at this time, I'm requesting his own recognizance release. Mr. McComb is absolutely not able to afford $300,000. Your Honor, he does have an address he could return to. He does have no criminal history, as the court noted, that NPRA score of a 0. Your Honor, he does work. He does work at Walmart, and he does DoorDash to help support himself. So with that in mind, Your Honor, this is not someone who can make a $300,000 bail, even 15% of that. I have no objection to pretrial supervision or to the no contact order, no unsupervised contact with minors. As far as house arrest goes, I don't believe that's appropriate here. I think that given his lack of history, I think that this is a situation where pretrial supervision will accomplish what needs to be done. If the court disagrees, I would ask that house arrest or GPS be ordered within 24 hours of release, given the difficulties we have and the additional expense incurred in getting that set up at the jail. With that, I would submit it, Your Honor.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the appearance, in order to ensure the safety of the community. The court will note the high likelihood of conviction, the significant threat and danger to the community based off of the allegations, as well as the significant steps, as well as the charges as discussed, where the state's the defendant's own words and actions are very significant. The court will also, just for the record, consider the only information regarding means that this court has is that he receives government assistance of Medicaid. So with that in mind, the state or the court will set bail in the amount of $100,000 that is bondable with no 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by pretrial services and must check in within 1 business day. The court is requiring that the defendant have no unsupervised contact with any minor children. Just for the record, the court did consider that he was a 0 on the Nevada pretrial risk assessment. That is going as, again, for why that amount is appropriate and reasonable given all the facts and circumstances. The court will go ahead and set a 72-hour hearing, which will be set for December 26th at 9:30 a.m. And that will be the only condition imposed. Thank you.
Thank you, Your Honor.
No unsupervised contact with minor children, yes, due to community safety and pretrial, yes. Nathan Peterson?
Mr. Peterson is waiving his appearance today, Your Honor. We can proceed without him if the court so inclined.
Thank you. We're here today for first appearance bail hearing. Probable cause has been found. The public defender's office has been appointed to represent the defendant. I am in receipt of the Nevada pretrial risk assessment, which indicates that the defendant score is a 4 or low risk utilizing that tool. State, are you ready to proceed with the bail hearing? And just for the record, we will go ahead and waive the defendant's appearance for today's proceeding.
Yes, thank you, Your Honor. So Mr. Peterson scores a 4 on the risk assessment, but he is a sex offender with a PMP hold. He's on parole for lewdness with a child less than 14 with a supervision start date of March 24th, 2021. And now here he is, while on lifetime supervision for a child sex offense, in custody on new child sex crimes. It just boggles the mind. So he's got that 2003 felony conviction for lewdness with a child less than 14, 2021 gross misdemeanor convictions for possession of stolen property and embezzlement. Very clearly, there are no least restrictive means that this court can impose to keep the community safe from this defendant. He's already on supervision for a child sex offense, and here he is trying to have sex with a child. So the state is requesting a very, very high bail amount, one that hopefully will ensure that this defendant stays in custody. Detention level bail is the only appropriate amount in this case. So the state is requesting bail in the amount of $5 million. House arrest with GPS prior to release. No contact with minors, schools, or places where children frequent. I know the court's position on that, but the state would request it nonetheless. And I'll submit.
Thank you. Defense?
Thank you, Your Honor. Your Honor, I think we've set a record. This is the highest requested bail that I've seen in my tenure here. Your Honor, my understanding that my client has that parole hold, I will note he does have that NPRA score of 4. I don't think he's going anywhere, but with that NPRA score, I think that $5 million is unnecessarily punitive. I would ask that the court set something perhaps in the $10,000 range. As far as house arrest and GPS goes, Your Honor, I don't think he's going anywhere, but If the court does see fit to order that, I would ask that he be allowed to get that installed within 24 hours of release, given the difficulties and additional expense in getting that installed in jail. I have no objection to and no unsupervised contact with minors order. I would otherwise submit.
Thank you. Thank you. I'll just note for the record that based on the facts that presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note that a detention order is appropriate in this case. This court does have a little bit more information about the defendant's means in terms of that he was employed, that he does have own vehicles. We don't have any information as to whether or not he owns any property. The court does have information that he rents, and so I'll just note that is that the court's taking that into consideration. Additionally, with respect to the likelihood of conviction, which is extremely high in this case, the history of similar offenses, the significant danger to this community that the defendant poses with respect to minor children, based off of the prior conviction of a similar offense involving the same allegations and significant danger, as well as that he was currently under supervision while he is alleged to have committed this offense. The court does find that a detention order is appropriate in this case. Bail will be set at $1 million. That will be bondable with no 10% cash option. If the defendant is able to post that bail amount, I will require that he be supervised by the Department of Alternatives, or sorry, my apologies, that he be supervised by pretrial services and must check in with pretrial services within 1 business day of release. I will require that he be subjected to GPS monitoring and that he have that installed within 24 hours of release. I do find that that is necessary in order to ensure the safety of the community. I will require that the defendant have no unsupervised contact with minor children and comply with all requirements of his parole conditions. State, just to make sure that it's clear of that, I don't have the information as to what the specific conditions are of his parole, so that may include and is likely to include that he's to have no contact with minor children. What I do see here is that he does pay child support, so he does potentially have a minor child, and so the court is considering that, but I'm sure that there's conditions indicating that he's not to go on school property, things of that nature. So he'll have to, if those are part of his conditions, he will be required to follow that. That will be the order of the court, and we will go ahead and set a 72-hour hearing, which will be set for December 26th at 9:30 a.m. Just for the record, I do find that all these conditions are necessary in order to ensure the safety of the community. However, alone, they are not least restrictive means to permit an under cognizance release. And I believe that is everyone. Just want to confirm.
Looks like we got everybody, Judge. Thank you.